Hello and welcome to episode number 1 of EdjuristTV. Today we're going to be talking about the Pontiac versus Spellings case. It's a big case out of Michigan and the 6th Circuit that could have big national implications. I went up to the 6th Circuit hearing, en banc hearing, about a month ago where my friend Gina Umpstead was also, and so we talked afterwards and thought it'd be a good idea to do a podcast on this topic. And so that's what we're doing today. So, first let me give you a little background on the case, and then we'll bring Gina on board and we'll discuss some of the intricacies of the case and also think about maybe guess how it'll come out and also if it'll have any implications on NCLB's reauthorization that should come up this year or next year. So, Pontiac v. Spellings is a big-time case about the unfunded mandates provision in No Child Left Behind. So you're like, I never heard of that provision in No Child Left Behind. Well, let me give you a little background on the unfunded mandates provision first, and then we'll talk a little bit about the procedural history of Pontiac versus Spellings. Okay, the unfunded mandate provision says this. Nothing in this act shall be construed to authorize an officer or employee of the federal government to mandate, direct, or control a state, local education agency, or school's curriculum, program of instruction, or allocation of state or local resources, or mandate a state or any subdivision thereof to spend any funds or incur any costs not paid for under this act. Okay, that's a lot of legal lingo, right? So what does it mean in layman's terms? Well, let me just cut out some of that crap in the middle and focus on the key provisions here. It says, nothing in this act shall be construed to authorize an officer or employee of the federal government to mandate that any state or local educational agency spend any funds or incur any costs not paid for under this act. So what does this provision mean? Well, that's the issue in this case. You have a bunch of school districts in Michigan that joined together and brought a lawsuit against the Department of Education, saying essentially this. The unfunded mandates provision applies to all of NCLB. Thus, all of the mandates within NCLB are subject to the limitation that Congress can only get the amount of implementation from the states and from local school districts that they pay for. In their opinion, it takes a lot more money to actually implement NCLB than Congress has actually expended on it. Thus, according to the local school districts, they should only have to implement the amount of NCLB that they have money for, and they'll determine that amount in negotiations with the Department of Education. Now, obviously, the Department of Education and the federal government comes at this from a very different angle. They're saying, no, this is a very narrow provision that only applies to the specific elements of this act that refer to the Department of Education and their grant-making capability. Essentially, what this is saying is no other employee of the federal government besides Congress should have the ability to add on additional unfunded mandates that didn't previously exist in the actual legislation itself. So this doesn't sort of apply to Congress, this applies to the Department of Education. It's much more narrow reading. I would say that it is a much more historically accurate reading of cases under the spending clause. But in this particular case, we have a specific statute, this unfunded mandates provision, that says what it says, we just talked about, and so maybe NCLB should be treated differently. Okay, so the school districts bring this case to the 6th Circuit. First they bring it to the Michigan District Court. The District Court finds for the Department of Education saying, spending clause legislation is pretty clear in this country. This provision is not that broad of a provision. It only limits Department of Education employees in this additional spending that we talked about. A very standard decision. Then goes up on appeal to the 6th Circuit Court of Appeals out of Cincinnati. A 3-judge panel on that 6th Circuit, on the 6th Circuit said, well, at least 2 of the judges said, the opposite, saying that this is the broad provision that we were talking about, and it does have limitations on all of NCLB, not just on the federal government, but also on Congress and all of the mandates that are inside of this act. So 2 of the justices said that, 1 justice dissents. Because this is a fairly odd opinion, and maybe the 6th Circuit's not real fond of it, they decided to hear it en banc. Another reason was because one of the judges on the case was filling in at the time. It was a district court judge that was filling in at the appellate level. So they decided to hear it en banc, and I had the honor of being at the en banc hearing, as well as Gina Umpstead and Mark Walsh. And a lot of people were there, the NEA's top lawyer, the Department of Education's top lawyer, arguing this case. It's a big-time case, can have big-time implications, and that's the kind of stuff we want to talk about with Gina Umpstead, who we'll bring on board right now. So we welcome in Gina Umpstead. Gina is an assistant professor at the Central Michigan University, where she teaches educational law. She's clerked for the Michigan Supreme Court, worked for the Michigan Attorney General's office, taught courses at Michigan State University, and she's also worked in private practice. She has her JD from the University of Michigan Law School and her PhD in educational policy studies from Michigan State University. Her most recent article in the Journal of Law and Education is titled "The No Child Left Behind Act. Is it an unfunded mandate or a promotion of federal educational ideals?" So she's a real expert in educational law and on NCLB, and she's also an expert on Michigan issues, and this case comes out of Michigan. And on top of all that, she's just a good friend of the Edjurists and of me personally. And so we're happy to welcome in Gina. Hey, Gina, how are you?
Hi, Justin. Thank you.
Great.
It's nice to be here.
Yeah, thanks. Sorry that you have to be like the guinea pig on this whole experience, but that's just you should feel honored. Maybe I don't know.
I think it's going to be very fun.
Okay, super. So let's talk a little bit about Pontiac versus Spellings. This is the case that you and I had the privilege of going to the en banc hearing for in Cincinnati, and it's, as we said a few minutes ago, it's a pretty important case that could have some far-reaching implications if it comes down a certain way. And so we're here to make people a little bit more informed about it, and we thought, why not bring on a national expert like yourself to help us learn a little bit about this case. So maybe first you can just give some of your general thoughts on this case and some of your background working on this case.
Okay. Well, I became interested in the case when it first started in 2005. I have been in the legal field for quite a while, but I've been in education maybe 5 years. So I was really interested in this since it dealt with such an important piece of legislation, the No Child Left Behind Act. Mm-hmm. And it looked also at the role of both the federal and the state government in the field of education. And plus, I came out of Michigan, so
sure.
I'm from Michigan.
Since it's local.
This is a great case for me to check into. So I started back in 2005 when it was first filed, and came up with this idea to write the article to really examine the legal arguments that the parties were presenting in both the Pontiac case and then also the similar case that was filed out in the district court in Connecticut by the state of Connecticut.
Okay. Yeah, very interesting. Yeah. So we should probably say something about the case out of Connecticut. It's a sort of a companion case, I think, to the Pontiac case in many ways. In that case, and you can feel free to correct me if I'm wrong, because you know more about this than I do, but the state of Connecticut sued the federal government saying broadly that there was not enough money attached to No Child Left Behind to implement all of its mandates, and that maybe you can help me. Did they want to keep the money but not have to follow the mandates? Was that the idea?
Right. So it's very similar to the Pontiac case. The parties are different because the parties in the Pontiac case are the National Education Association, a number of local school districts, and a number of local educational associations. But the Connecticut case came in and made a lot of the same arguments that the Pontiac plaintiffs were making. So they did say, well, No Child Left Behind really is an unfunded mandate. There's a specific provision in the Act that they call the unfunded mandate provision that says basically states can't be required by the federal government to spend any funds or incur any costs not paid for under the Act. And so they made that basic argument, but Connecticut also made additional arguments under the 10th Amendment, under the spending clause, saying that essentially the policies by the Secretary of Education are coercive because the federal funding is so important to education in the states that states have no real choice but to accept the money, And they did that by focusing specifically on the fact that Margaret Spellings wouldn't grant certain waivers that they were requesting.
Yeah. So this whole talk of it's becoming a money kind of lawsuit lately. Earlier on, you had some states like Utah that were just not interested in doing the whole package. But lately, it seems this unfunded mandate kind of idea is the idea that's the big idea in the court system. So what do you think about this unfunded mandate? I know this was a big part of your article, and maybe you can speak to a little bit, especially the stuff you talked about, compliance versus compliance plus proficiency. That stuff you had in the article I thought was very good, and I think it's good to share.
Right. So the argument in the case really centers on the one clause, that's the unfunded mandate provision. And a little bit of background on funding and education probably is important in that states fund about 83% of all educational costs in the country, right. And they have constitutional authority to control education. So that's part of what makes this case really interesting. So the federal government comes in and offers 7 or 8% of total education funding and says, we want you to do all of these requirements under No Child Left Behind.
Right.
Well, once the act was passed, a number of states decided to run cost studies and say, how much is this really going to cost us? How much of it is funded by the federal government? How much of it is not funded? Mm-hmm. And what I found when I looked at some of the research is that there were a number of different ways, but really two fundamental ways that I focused on. And one was this idea of compliance costs. So what are just the basic additional requirements that No Child Left Behind has states do? Things mm-hmm. like create standards, test all students, make sure your teachers are highly qualified, report student test scores to parents, those kind of things. So you can look at those as just basic compliance costs, or you could look at it as a number of states did and say, how much is it really going to cost us to get all kids up to this level of academic proficiency that No Child Left Behind is talking about?
Yeah.
And the estimates range from about 2% nationally
sure.
to 35% if you're really talking about the proficiency costs.
Yeah, I think that's an important point to say, the difference between doing a good job and just doing the minimum required, and the idea of getting all students to proficiency, this mandate included in No Child Left Behind, where at 2014, everyone's got to be at proficiency. That's a major undertaking in the states, and to actually trying to accomplish those goals are quite different than just implementing the testing mandates under No Child Left Behind. So I do think that's an interesting point, and I think it does weigh in the case of what does the federal government require? They just require the testing, or do they require all this additional work that needs to go into actually having your students pass the test? I think
right, and the law really calls for both.
Yeah, I mean, the law definitely calls for both, but whether or not the federal government should be the funder of the second part of actually getting everyone to proficiency, I think is maybe the more interesting question. The federal government's maybe saying, well, we are helping to fund the cost of the test, but we're not going to help fund the cost of you implementing statewide standards and making your kids proficient at them. I think that's a very interesting distinction from a funding standpoint.
Right, and that's exactly the point that I made in the article, because I agree with that.
Right. So let's talk a little bit about this particular provision in No Child Left Behind that's at issue in the Pontiac case. This unfunded mandates provision is how it's broadly referred to, but the language that we read earlier before you came on board is a little bit more specific than just saying no unfunded mandates. So maybe you can talk a little bit about your feelings on that provision, and maybe I'll say some of my thoughts on what that provision might mean, because that's really central to this whole Pontiac case. Is what the heck is that provision even doing in there? And since it's in there, what does it mean?
Right. So this provision, it's 7907A, which is the unfunded mandate provision. It was introduced into ESEA, the Elementary and Secondary Education Act, back in 1994. And it just seems like it's still there. Congress included it again. There was no discussion about it during the hearings or the debates about the new law. So we don't have any guidance really from the legislative history in that respect specific to this reauthorization. And so the arguments around it focus on the two parts of it. The first part that talks about that nothing in this act shall be construed to authorize an officer or employee of the federal government to mandate. So defendants in the case, the Secretary of Education, really focus on this part of the language, officer or employee of the federal government. There's some sort of restriction on them. It's got to mean something. Mm-hmm. And the plaintiffs, the NEA, and the school districts really focus on the last half of the provision, saying that the federal government can't mandate the state or any subdivision thereof to spend any funds or incur any costs. And so they really focus on that and say, any funds, any costs,
right.
If you don't pay for it, we're not going to do it. And so that's really the crux of the debate there and what it means. In my article, I talk about how to analyze that. And what I suggest is essentially what the Secretary of Education is arguing is that looking at the whole structure of the Act, mm-hmm. That this provision is best read to limit the authority of government employees to add additional costs on that weren't originally contemplated in No Child Left Behind. Because if you look at the basic requirements of the Act, you look at the fact that you've got to have standards, you've got to have testing, you've got to report student test scores, things like that, that's really clear. There's no ambiguity in that part of the statute. Mm-hmm. And also the fact that if states aren't able to bring kids up to proficiency, then there's a certain consequences that are going to occur, school improvement, corrective action, and restructuring that take place in a sequential manner. And so I agreed with what the Secretary of Education said in looking at this and saying, really the costs of compliance aren't mentioned in the Act. It's not funded in a way that says states tell us how much this is going to cost you. It lets states define what it is they're going to do to meet the requirements under No Child Left Behind, and then says, okay, once you tell us that you're going to meet them, now we're going to hold you to meet them. If you don't meet them, we could possibly withhold funds from you, or we're going to have these consequences that are going to take place in your schools.
Oh, very, very interesting. So let me play a devil's advocate for a second and say, just approaching this from the NEA's position, the provision specifies the officers of the federal government. Could that not mean Congress itself instead of meaning the Department of Education? I mean, I know that sort of seems to be the difference between the district court decision in this case and the first appellate court decision in this case, where the district court was saying, yes, following just along what you were saying, that this is a provision that applies to the federal employees at like the Department of Education. And then the appellate court sort of went the other way and said, hey, no, this is a broader provision that speaks to Congress generally, and the general provision in it applies to everything within No Child Left Behind. That how else would states interpret this provision other than the federal government will pay for what it asks us to do? So why would this not mean Congress generally? And what of the appellate court's argument that the first appellate court argument, the three-judge panel, that we should err on the side of the states in this scenario, that we should, when this is in doubt, we should just assume that it's broad instead of narrow.
Right. Yeah, so the argument that the Court of Appeals in the first decision and the three-judge panel came out with really focused in on the clear statement rule mm-hmm. under the conditional spending clause yes. of the Constitution. And so it said, basically the crux of the decision said that a state official could plausibly contend that they thought they wouldn't have to spend any money that wasn't directly paid for under the No Child Left Behind Act, looking at this particular provision. And that decision didn't surprise me. Because,
really?
I agree with the Secretary of Education's interpretation of this particular provision. Because of the structure of the law, because of all of the specific requirements, because of the fact that the law doesn't really deal with costs, it lets states define their own systems, and so it's not really workable to say, well, if a state claims that they don't have enough money to do it, then they just don't have to do it because the law clearly requires that they do it anyway.
Right.
But, the reading, and I talk about this in my article, the reading of that particular provision is somewhat problematic for the Secretary of Education because, it is somewhat of a reasonable reading to do it that way, but not in light of the whole context. And really one of the principles of statutory construction says that you need to read a provision in light of the whole law. And so if you just pull one provision out and say, okay, well, this might mean this, but it might mean that, you really need to harmonize it with the whole law, and that's ultimately why I concluded that it's better read that it just limits the authority of certain government employees rather than Congress as a whole.
Right. So in that vein, and since we were at the en banc hearing, we heard the arguments on both sides. One argument that I found particularly weak, and I'd like to hear your thoughts on it, is the government's argument, the Department of Education's argument, that parts of NCLB function like mandates and parts of NCLB function like grants, and that this provision was applying only to the grants provision. So what did you make of that? I found that just a very confusing argument, and I really didn't think it advanced their cause at all, but maybe I'm missing something.
Well, it was a new argument, so I was surprised to hear it, but when I thought about it, it's really consistent with the rest of their argument, but it's not one of their main points. So I was surprised that the attorney was making that argument. So if you look at No Child Left Behind, it has 10 titles, and so the one that's really in question is Title I, because that's where most of the funding comes through.
Absolutely.
That's the one that's improving the academic achievement of the economically disadvantaged. So that's the one at issue, and so the unfunded mandate provision is in the general provisions section of it, so that's actually Title X, or actually I think it's Title IX, and it refers back to all of the other titles, so it covers everything. And so what the argument is, what she was saying is that basically the other provisions are more voluntary. States just define all they have to do really is submit a plan and say, we're going to, for instance, under the 21st Century Act, we're going to reduce crime, we're going to reduce drugs in our schools. Here are the 5 ways we're going to do it. Here are the 5 ways we're going to measure that we've been successful. Please give us money for that. So if you have that kind of voluntary grant program that really doesn't have many requirements.
Which is a big part of NCLB. There's a lot of that in there.
Right. That makes a lot of sense compared to something like the more specific provisions under Title I that call for the accountability systems and the testing and the consequences if they're not met. So it's consistent with really what the Secretary of Education has been arguing all along, but I agree it is consistent. I thought it was a weird limb to walk out on at this point in the hearing, at the en banc hearing. And then sort of stick to it when the judges pressed her on it. But anyway, I do think it is consistent. I think it is getting back to this federal employee idea where it was really just meant to limit more of the Department of Education rather than limiting Congress's ability. But I did think it was an odd position to take. Yeah, I can see that.
So what about the standing issue? Some of the judges at the en banc panel were pretty concerned with standing. Do you see that being a problem at all?
That was another interesting issue because it wasn't argued extensively, at least at the Court of Appeals level. It was brought up at the district court level, and so the district court had dealt with the issue. So the question is really, here are school districts and the National Education Association bringing this case, and really the agreement under No Child Left Behind is between the state and the federal government. So why is the state not bringing the claim? Do the school districts actually have the ability to bring the claim? And school districts do bring claims against the federal government. The test that they apply in terms of standing is not that strong. It's really you have to have an injury. In fact, so the school districts claim that they spend their own money to comply with No Child Left Behind. You have to have traceability. Essentially, it's something that the federal government did is causing the school districts to spend this money. And so they're saying, it's No Child Left Behind, they're making us do it. And redressability, essentially that the court is able to offer some sort of remedy. And obviously if the court ruled that states and school districts didn't have to pay for things not covered not specifically funded under No Child Left Behind, then they would have a remedy. So on the one hand, they do meet the standing threshold. On the other, it seems odd that, it seems like there should be more of a connection there, and that really it should be the states that are bringing this claim. There was a similar case, the Board of Education of Ottawa Township versus U.S. Department of Education, that was decided out of the Seventh Circuit.
Out of Illinois, right?
Yeah.
Ottawa, Illinois,
out of Illinois last year. And so there was a similar standing claim there because you've got a school district suing the U.S. Department of Education. It was a question about whether a conflict existed between the No Child Left Behind Act and the Individuals with Disabilities Education Act. The court, the lower court said, that they didn't have standing because the actions that they were contesting, which was like the AYP determination, adequate yearly progress determination, was made by the state, not by the federal government. But then the Court of Appeals said, they're standing because there's really not much required to meet the standing.
Interesting. So you think we'll get over the standing hurdle?
Well, a couple of the judges were really interested in it, so it might be an easy way to say, no, we're not going to, you don't have standing, we're not going to decide this case. Yeah,
I agree with you. There was a couple of judges that were really stuck on it. I definitely don't like the standing claim. I think that the school district should be able to proceed on standing issues, but the judges were definitely interested in it, which brings us to our next question of, so how do you think this case will come out? What do you think the en banc panel will do?
Wow, that's a great question. I think because they picked it up, they're going to reverse it.
Yeah, I agree.
I think they should reverse it just because of the way that I view the law and the requirements. I don't think that states – I think states hoped that they wouldn't have to pay for things. Right. But I think they knew what the requirements of No Child Left Behind were. So that's my prediction. But go with it.
I'm definitely going to predict the same way. I do think they will reverse the three-judge panel's decision here, and I think the case will end there. But I'm actually in favor of them upholding the three-judge panel's decision. Not that I really love this case or love this argument, but I do think it's time for a slap on the wrist, so to speak, for Congress and the Department of Education generally. I don't want to see them proceed so quickly with federal involvement in education that it becomes where they're mandating things and they're not really funding anything. And I could easily see it going that way. I mean, President Bush, who was the advocate for No Child Left Behind in the first place, was a conservative. And so if this is what conservatives are doing, it concerns me then what a liberal president might advocate for, such as Obama, on this No Child Left Behind reauthorization that we got coming up. So do you think this case will affect NCLB reauthorization at all?
I definitely think it'll affect the reauthorization. Not directly, but it really, more than anything, what this case does, it sends a strong message that a lot of school districts and the National Education Association, some states are really unhappy with the way that No Child Left Behind is currently structured and currently funded in particular. Yeah. There was an increase in funding initially with its passage, 25% in federal funds, and it's just kind of held steady over the years. But since the funding is such a small percentage of overall education funding, it's difficult to say that was, necessarily enough. Probably for compliance costs, but not for proficiency costs. So I think that they're really going to think hard about the funding levels. I know they're talking about an economic stimulus package to include a lot more funding right now. And, I think they're also going to think hard about the accountability mechanisms because that's, the funding and then the fact that there are pretty severe consequences for schools that don't meet the proficiency requirements. Those are the 2 points that I think will really be under consideration.
Wow. I pretty much agree totally on your assessment. I don't, like I said, I predict this case will not go forward. I mean, if they affirm the three-judge panel, obviously it'll have a huge impact because we're probably going to have to see the Supreme Court getting involved in this case. But more likely than not, they're going to reverse. But I still think that this is going to have an impact. I mean, they may even wind up doing something with this provision, the unfunded mandates provision that currently sits in there. I mean, I could easily see Congress sort of getting rid of that provision. I mean, I could see...
Right, it's going to definitely draw their attention to it.
Yeah, certainly. I mean, I could see conservatives wanting to keep it in, but given the current makeup of the Congress, I could see him pulling it out just so it's not a problem anymore now that this case is sitting out there. And then I agree with you that we do need to take a hard look, which is why I'm in favor of a little bit of a hand slap at what the federal government's doing with funding levels. I think that's an excellent point. So overall, I mean, I think this is a fun case to really sort of point out exactly how NCLB and the states are interacting when the rubber meets the road, and that's money. And so, even though in the end it may come down that the Department of Education in the U.S. Congress is okay in putting No Child Left Behind forward, I still think it was a really great case to point out some of the flaws in the federal government getting involved in the way it has with these big mandates, these big testing regimes. And your point with proficiency, I think, is excellent. They put in a testing regime, but to actually get proficient in it is a much more expensive proposition. So I think it's really, you brought a lot to the table here, and we're happy that you contributed to the Ed Jurist and passed on your knowledge to all of us. So thanks, Gina. Again, the article, if you want to check it out, is titled "The No Child Left Behind Act. Is it an unfunded mandate or a promotion of federal educational ideals?" It's in the latest edition of the Journal of Law and Education. So check it out and keep an eye on Gina. She's a big player in our education law field, and we're looking forward to getting a lot from her in the future. So thanks, Gina. Any last comments, any parting ideals to the Ed Jurist community?
No, I'm just excited to see how this is going to turn out and watch, what the new administration is going to do in terms of education. And
yeah, it's fun, isn't it? I mean, it's a fun job, no doubt about it. So anyway, all right. Well, thank you, Gina, and we look forward to maybe chatting with you again in the future sometime. So
thanks. Justin.
Yep. All right.